One.
Продовжуємо засідання. Прошу
Let's
запросити
continue our meeting. Please invite Yatsynina Marta-Mariia Serhiivna into the room.
Доброго дня.
Good afternoon.
Розглядається питання щодо відповідності
We're
кандидата
considering the issue of compliance of a candidate for the position of the judge of the High Anti-Corruption Court, Yatsynina Marta-Mariia Serhiivna, with criteria set out by Part 4 of Article 8 of the Law of Ukraine on the High Anti-Corruption Court of Ukraine. We have members of the PCA present: Robert Heinbrook-Harping, Norman Oz, remotely, Mary K. Butler remotely, Gabriela Yudovsky-Dovotskiene, John J. O'Sullivan, and Jessica Lott Thompson. Members of the HQCJ: Михайло Боганіс, Людмила Волкова, Ярослав Дух, Роман Кадисюк, Надія Кобецька, Ігор Кушнір, Олексій Омелян, Андрій Пасічник, Сергій Чумак, Wilcom, Галина Шевчук. You have the right to request recusals, to submit motions, to provide explanations on permission of the chair to express your position and challenge decisions of the commissions. Do you have any recusal requests? I have no recusal requests. Thank you. The co-rapporteur is Commission member Ruslan Mikhailovich Sidorovich, please. Thank you. Thank you for this opportunity to present the candidate. So, Madam Marta-Mariia, I will be the co-rapporteur on behalf of the HQCJ regarding your candidacy. You are ready for the questions, you are ready for the interview. So now we will have a general presentation and then we will have questions. So with the decision of the HQCJ dated June 3rd of 2025, number 112, there was announced competition for filling in 23 vacant positions of the High Anti-Corruption Court and the Appellate Chamber of the Hague. Within the deadline, Yatsynina Marta-Mariia Serhiivna applied as a person compliant with requirements of paragraph 4 of Part 2 of Article 7 of the Law of Ukraine on Hague. So her total experience of professional activities as the attorney and is at least 7 years. With the decision of the HQCJ dated September 18 of 2025, Yatsynina Marta-Mariia Serhiivna was admitted to qualification evaluation and participation in the competition. With the decision of the HQCJ dated September 19 of 2025, there was appointed qualification exam within the framework of competition for filling in vacant positions in the High Anti-Corruption Court and Appellate Chamber of the High Anti-Corruption Court. With the decision of the HQCJ dated September 19 of 2025, there was appointed qualification exam and the order of its conduct was determined. With the decision of the HQCJ dated February 4 of 2026, there was updated general results of the first stage of the qualification exam. Pursuant to results of this qualification exam, Yatsynina Marta got 315.17, and she was admitted to the second stage. With respect to the qualification of the candidate, brief information. In 2014, the candidate Yatsynina got diploma of the master's from Lviv National University of Ivano Franko, and she got full higher education under legal sciences and obtained the qualification of the master's in law. In 2021, candidate got the diploma of the PhD in the Institute of State and Law of Koretsky of the National Academy of Sciences of Ukraine and the specialty criminal law and criminology. The topic of the dissertation is abuse of authority, official position, or powers under the Criminal Code of Ukraine. The academic title is absent. Professional activities looks as follows. Starting from 2014 to 2022, the candidate worked at the position of the legal counsel in different enterprises. With the decision of the Council of Lviv region, the candidate got the attorney's license on the 21st of December 2017. During the period from 2017 until 2022, the candidate was actively engaged in attorney's activities. Since 2022, the candidate has worked the position of the senior lecturer of the Faculty of the Theory of Law and Human Rights in Ukrainian Catholic University. The candidate submitted declarations of family ties, declaration of integrity, and asset declaration for 2024. This way, requirements of the law have been complied with. That is general information about our candidate. Mr. Andriy, the floor is yours. That's it from my side. Thank you. I'm passing the floor to Mr. Robert now.
Thank you, Mr. Chair. The rapporteur on our side is Jessica. Please, Jessica, go
ahead. Thank you, Pani Marta-Mariia Serhiivna. My name is Jessica Lott Thompson. I am a lawyer from Canada, and I'll also introduce our panel members. We have John O'Sullivan on my far left, who is a former judge and former prosecutor from the United States. Robert Hein-Broekhuizen, who is a senior attorney from the Netherlands. And Gabriel Džotkate, who is a judge of the Supreme Court of Lithuania. And also on the screen, we have Mary Butler, who is a senior prosecutor in the United States, and Norman Aas, who is a private attorney and former prosecutor in Estonia. So I'll proceed today with some questions. Before we begin, are you ready to proceed?
Yes.
So I'll ask you questions about different themes. Please feel free to add additional information. So we'll start and talk about your employment. We've had an opportunity to exchange several rounds of written questions, so I'll be able to focus my questions on the issues that are worth discussing. According to the information you provided in your candidate questionnaire, in the period between 2014 and 2022, you worked as an in-house counsel with a series of 11 limited liability companies. These positions followed one another over short periods of time, generally without gaps, sometimes changing only to the very next day. And all of these companies were registered to the same business address in Lviv, and they all used the same phone number. You indicated that the reason for changing positions was by way of transfer. We've discussed a list of those companies and the details about the dates. There are approximately 10 companies over 7 years. I'll ask you some questions about this situation. Can you explain the nature of the business activity of each of those listed companies and indicate how long those companies had been operating before you were employed with them?
Thank you for your question. Each of these companies engaged in a sale of oil products through the network of gas stations in the Lviv region. When I was transferred there, there was an agreement between two enterprises that from one enterprise, all employees will be dismissed and transferred to another enterprise. So we had guaranteed employment, and we all of our vacation leaves were also transferred to a new enterprise. I was not following activities of these enterprises before our transfer as to how long they had been working. I was working there once I was transferred to a new enterprise.
And were you at any time in a position as a director of one of those companies, or were you only an employee as in-house counsel?
Ні, я жодного
No,
разу не займала
never.
жодну
Never I have had any administrative positions. I was also always the legal counsel, the ordinary legal counselor. And also there were other legal counselors at the enterprise, and even attorneys from different spheres of law were employed by the companies.
Okay. Are you aware that according to publicly available information and media reporting, as well as reports received from CSOs, the ANP gas station network has been associated with the so-called Privet Group and with businessman Ihor Kolmosky, who is currently subject to criminal proceedings in Ukraine, and in relation to suspicion of fraud and embezzlement. Can you please explain any connection that you are aware of now or were previously aware of between this gas network and Privet Group?
Цю інформацію я могла бачити в засобах
I could
масової
see this information in the mass media. I cannot recall when specifically. I remember that lots of information appeared in 2025 when these gas stations were sold. Before then, it's difficult for me to say the specific year when I could read this information in the mass media. About the structure of ownership, as a legal counselor, I never worked with that, and I never saw that information as a lawyer. This information was never available in the right register of legal entities, and no one informed me, even informally, about that. So, as a lawyer, I did not see that official information. With Ihor Kolmosky, of course, I do not know him. Even if it was true, I was the lawyer of the lowest possible level at these enterprises. And back then, when this person was notified of suspicion, I already resigned from those companies.
Okay. Can you provide any, now that you are a scholar and it has been a few years since you were working in this role as in-house counsel, can you provide some scholarly assessment about this practice of transferring the title of ownership of businesses, which I understand in Ukraine is legal, but can you provide any scholarly assessment about this practice, whether it is common, and any concerns that it potentially raises for you in a broader sense of business practices in Ukraine?
Стосовно такої практики
With respect to this practice of transfer, here I would like to point out that no one asked about my opinion, and my opinion did not matter at all. I was just informed, like other employees who were working there, about that. With respect to the legality of this procedure, I did not have any concerns because there was not direct or indirect prohibition in the law. For me, it was important not to have any procedure of tax evasion, because I, as an employee, is subject of this process when the salary is paid to me and when taxes are paid for me as a hired employee. There were no problems with this procedure for sure. I was officially employed, all of my salaries officially recorded, all the taxes were paid. So from this aspect, I as an employee had no concerns. With respect to overall culture of corporate governance, then of course, I as a person who is studying activities of public officials, who is studying this topic, I would not do that because in my opinion, that's unreasonable use of resources. And any business activity should be planned for longer periods of time rather than it was happening there. But that's my personal opinion and no one asked me for that and it did not play any role back then.
Thank you. My final question about your period of employment. Can you tell me about the types of cases and areas of law? Please do not reveal any confidential information, but which types of cases were you involved in? Criminal, commercial, financial litigation, solicitor work? Please give more details about your work experience during those years.
Дякую. Як я вже зазначила,
Thank you. As I have mentioned, we had several legal counselors. Each was responsible for their own sphere. I was responsible for the sphere of representation in court. In those spheres of public relations where I was competent. So until now, I've developed my practice in the sphere of taxation disputes. And I was representing the company in taxation cases in administrative court. Also, there could be some separate commercial disputes, but I cannot recall everything about 10 years. So I was representing mostly in administrative and commercial courts and mostly in taxation-related cases.
Thank you. I'm going to move on to the next topic. I'd like to discuss a purchase of a vehicle that you made in 2019. According to your declaration in 2024, in August of 2019, you purchased a Kia Sportage vehicle, which was a year of manufacture of 2019, with a cost of approximately $22,000 US. At the same time, according to your mother's declaration, and you live together with your mother, for 2018, your declared savings amounted to only $10,000 US approximately. Can you please explain the sources of funds by which this car was purchased and indicate how it was financed from your personal savings, income, or other sources? We have received some supporting documents and some charts and information from you and had an opportunity to evaluate that. But can you please explain on the record how you financed this vehicle, which exceeded the amount of savings that you were declaring at this time?
Дякую.
Yes, thank you for your question. Indeed, as I mentioned in my explanations, indeed, in 2019, I purchased Kia Sportage vehicle produced in 2019. That was the first purchase of that car together with my mom. We have been saving funds to purchase it. We have joint households, and I have provided calculations how much money we saved during that period of time. I provided also estimations of remuneration of my mother since the very moment of started saving until the first quarter 2019. Why in quarters disaggregation? Because my remuneration and mom's remuneration is divided in the tax system quarter by quarter. That's why I provided like this. And correspondingly, during that period of time, while we had been saving together with my mother, so I provided you with a table where I mentioned the income per year, USD exchange rate at that specific year, and how much, what was our remuneration in USD during that period of time. So my mom had accumulated some money starting 2008 to first quarter 2019. Yeah, of course, at that moment, the very beginning, she didn't know that we are going to purchase that vehicle. And at that moment, the salary was more than $68,000 for all those years. I started working starting 2014, and for the first until the first quarter of 2019, my income was more than $27,000. So in such a way, during this whole period of time, we managed to accumulate these savings, which were reflected in my mother's declaration for 2018. These savings were deposited starting 2016 to the end of 2018 at the bank account. And I provided you with a bank record where you can see that we have deposited money in 2016 at the bank account, and at the 2018 we have withdrew money. Out of this money, $8,000 were her savings, $2,000 were my savings. They were at the same bank account, first of all, because we had joined household, and now I don't know whether I need to explain it right now. There was a certain situation, dangerous situation, because of which we needed to take all our money together and put them into the bank account and conclude a bank agreement. That's why $8,000 of my mom's and $2,000 of mine, they were stored at the bank account till the end of 2018. Then, at the end of 2018, the situation at our household has improved. We felt that.
Let me just encourage you to speak a little bit more slowly. The interpreter is struggling to keep up and she needs to breathe a little bit. So I'll just encourage you to, at the conclusion of each sentence, just take a small breath and we'll allow her a chance to catch up. I just want to be able to be sure that I can hear everything you say.
Добре, дякую.
Yeah, of course, thank you.
Отож, це
So,
були $10,000.
These were $10,000, which we withdrew from the bank account in the end of 2018. My mom, at that moment, submitted her declaration, even despite of the fact that she was not a subject of declaration process, but by just to be sure, to be on the safe side, she submitted her declaration. At that moment, there were no specific clear rules for declaring. That's why we decided that it's better to be on the safe side and to declare rather than not to submit any declaration at all. At that declaration, she mentioned those cash funds which we withdrew from the bank account, and she didn't ask me whether I have some savings, because she was 100% sure that all my savings were only at the bank account and there were no savings at home of mine. That's why she didn't clarify it with me. And when she submitted her declaration, she didn't clarify whether I have my own savings at home, but I had. And the amount was $5,000. My mom didn't know about it. This money I managed to accumulate during 2017-2018, and my salary for those 2 years, 17 and 18, in dollars, it's also indicated. 2017, it was more than $5,000. 2018, it was more than $8,000. Then, my mother, she provided written explanations, which I attached also to the council, that yes, indeed, she didn't ask me, didn't clarify this issue with me, specifically whether I had any cash funds stored at home, a part of those which were deposited in the bank account. Also, my mom had certain amounts of money which she didn't declare because it was lower than the threshold for declaring that less than 10 subsistence minimums. It was around 76,000 hryvnia. So 11,000 out of those 76 were at her salary banking card, and another part of the sum was in cash. Then she converted it in dollars, and then vice versa in hryvnia. So it was again 2018. Then the vehicle itself was purchased in August 2019, and starting January to June, we managed to accumulate 100,000 hryvnia. And I provided you with calculations that if we add this $10,000 plus $5,000, 86,000 hryvnias of mine and 100,000 that we managed to accumulate during 2019, we indeed can reach this amount necessary for the purchase. And plus, we have some additional funds left for to cover our livelihood, I think, to our expenses, and it was 85,000 hryvnias. All those calculations were done till June 2019. Then we got salary for July 2019 and August 2019, and that's why it was enough for us, because all calculations were provided till June 2019. That's how we accumulated those funds.
Thank you. I don't have anything further to ask about that topic. I'm going to move on to the next topic. Thank you for your very thorough answer, and also thank you for providing so many supplementary documents and evidences in the course of the questions. It makes it more productive to be able to move clearly to the key areas in this oral interview. The next topic I'd like to discuss is your PhD. During the analysis of your dissertation, we became aware of some substantive similarities that were identified with the dissertation of another individual, Edward Alexandrovich Skubak, who prepared a dissertation on the topic Legal and Psychological Characteristics of Abuse of Official Position by Civil Servants in Ukraine, which he defended in 2020. In particular, the comparative analysis conducted by the PCIe Secretariat indicates a similarity of certain sections in the structure, logic, presentation, and some factual material citations that are used. We have outlined those details to you, but specifically, I would like to discuss with you the sequence of events in relation to articles that you published in 2016 and 2017 and the materials contained in those articles. Subsequently, the article published by Mr. Skubak in 2020, and then finally your dissertation, which was published in 2021. I'd like you to please outline any coincidences and similarities, and to please explain this situation.
Так, дякую.
Yes, thank you. Actually, your questions very clearly reflected those similarities and the nuances of it. So specifics of those similarities are the following. That before before a scholar gives any conclusion regarding certain academic issue, a scholar shall show how it was studied before them, and it shall be referenced to some certain surnames. So my dissertation was defended in April 2021, and it means that references were the same as Mr. Skubak's dissertation, who defended it in December 2020, so 4 months before my defense of the dissertation. And actually, as I explained the citation, I started writing my dissertation back in 2014, and I did it gradually. And when one of some sections was almost ready, or I thought that it was almost ready, I published a relevant article on the topic of that section of the dissertation. And in such a way, I published an article on subjective parts and on the object of the crime. And I published those articles in 2016 and 2017. In 2016, the article was dedicated to the object of the crime, and in 2017, the article was dedicated to the subjective side of the crime. And it's there already. I made a conclusions who studied this topic before me. And this description is the same as in my dissertation. Of course, some conclusions have changed, some parts, the volume of the text has increased, but the chronology, who studied before me, who did what, that's the same both in my articles and in my dissertation. And the station was the following, that it was not me who copied this order from Mr. Skubak, but it was him who copied it based on my articles, because my articles were published in 2016, 2017. They are publicly available. I gave you references and links to those articles. You can check it. They indeed publicly accessible, and it could be checked that they were written by me in 2016 and 2017. And I also provided the council with the text of the articles, and I highlighted this order, the same as you did for me, to show that this order of events, of how it is logic, it was already there in those articles. So one may make an assumption that my dissertation was based on my own articles rather than on studies and works of other people. people. And also, I defended my dissertation in April, but as far as I remember, I submitted my dissertation to the faculty of the university on 30th of November. And I also shared with you the copy, the screenshot of the email that I sent the text of my dissertation on 30th of November. I submitted it to my postgraduate faculty. So it was before the moment when Mr. Skubak's dissertation was publicly available. And generally speaking, Mr. Skubak's dissertation is not on criminal law, so he's more focused on psychology or something like this. So later, when I found out about it and I looked I realized it. When I was writing my dissertation, I didn't need his dissertation to work on mine.
Thank you. I don't have any further questions on that. And I thank you for the thoroughness of the materials that you provided during the written questions as well. If my time still remains, Mr. Chair?
Sure.
I have an additional area of questioning. I'd like to ask you about your experience as an authorized person for the implementation of UKU, the Ukrainian Catholic University's anti-corruption policy. Since December 2022, for the last few years, you have been in this role as an anti-corruption official within a private university. Can you please describe in general terms your role and responsibilities in that position? How you carry out those functions in practice, and perhaps some details about how you balance the relationship that is complex with your subordination to the rector as an academic, as a scholar, with the requirement of independence in carrying out your duties. Can you please discuss this complexity and potentials for conflicts of interest and ethical issues, as well as a general description of your role?
Дякую. Так, з
Thank you.
2021
Yes, indeed. Starting 2021, I have been an anti-corruption authorized person in the Ukrainian Catholic University. My role started that together with the legal department and other departments, we have drafted the anti-corruption policy of this university. And now, as an anti-corruption authorized person, I'm implementing this anti-corruption policy. My duties and powers are the following: that I explain certain nuances of anti-corruption legislation at the education sector. I carry out outreach activities. I arrange different lectures, events, and other learning activities in the anti-corruption sphere and dedicated anti-corruption topic. And they are not only for students, but also for peer colleagues and professors. And also we have open anonymous channels regarding any need to report about such potential situations. And if we receive such claims in the commission, we make a decision what shall be done, how to consider such complaints. And of course, the university is a big one, and I definitely respond to complaints. So if there is a complaint and I see whether it's possible for me to initiate the study of the issue by myself, and I express my opinion as an authorized person on anti-corruption policy. But if I see any potential conflict of interest, I also report and disclose such information. And how I balance between being an anti-corruption authorized person and hired employees, and the first one shall be independent in their role. So first of all, a lecturer is already independent in their professional activities, because yes, I am a hired person, but we have independence in terms of lecturing, of learning activities. So, and I'm independent as a lecturer. And yeah, I don't want to to boast of my employer, but I do really want that all educational facilities in Ukraine be like my employer, my Ukrainian Catholic University, and for all employers not to interfere in the activities of subordinates as they do not interfere. But yes, indeed, the dean of the university doesn't doesn't interfere into my activities. I'm not afraid of voting at different sessions and meetings. I'm not afraid of making decisions. I'm not afraid of expressing my position, even if it's contradictory to position of the leadership of the university. Very often my position is harsher and stricter than position of the leadership. For example, if I want to initiate some kind of changes in terms of internal documents or internal rules and provisions, for example, some stricter punishment for violation of academic integrity. So I'm not afraid of it, and they do not interfere into my activities.
Can you tell me a little bit about any more details about the scope of the anti-corruption policies at the Ukrainian Catholic University that you are responsible for? Is it primarily related to scholarly situations of corruption, or is there financial corruption, issues of human rights and discrimination? Can you please tell us a little bit about the policy itself and the areas of law that are captured by it? I suppose also about the depth of your experience with particularly financial corruption related cases.
Actually, our anti-corruption policy concerns academic integrity of students and faculty members. Also, in our anti-corruption policy, we have some rules for procurement, financial relations, etc. That's why the anti-corruption policy covers that aspect as well. So that's not only about academic integrity. That's academic integrity of all the entities participating in the process, plus financial integrity. With respect to discrimination, we have other authorized officers in different spheres. And for example, in case of persons in need of special attention or some other sensitive topics are covered by other authorized officers who are responsible for other narrow spheres.
And my final question is, can you tell me something about your personal motivation to apply to the High Anti-Corruption Court? Can you please give us some information about why at this stage in your career you feel this is an appropriate step, and any specific challenges or areas of weakness in your application where you feel like you would need to do additional preparation, or any concerns you may have?
Дякую.
Стосовно with respect to the consideration of cases on this topic considered by the Hague, I have been interested in this topic since the master's level. So when I was graduating from the university, I was already interested in this topic, and my master's paper was on the topic of officials. And then I was preparing my thesis dissertation for 7 years. And now for 4 years, I'm fully dedicating myself to this activity. For the past 4 years, I'm teaching criminal process, responsibility of officials. I organize trainings for investigators and prosecutors in the sphere of criminal law. Besides, I organized different anti-corruption events and anti-corruption events. That is what I live with for the past 4 years. That is a lion's share of my time dedicated to this topic all the time. So that is the sphere that has been interesting for me since the master's level throughout my entire professional life. That's about the topic considered by this court. With respect to the role of the judge and not some other participant of the process, there was a period of time when I really liked being an attorney, and I actively engaged in attorney's activities. But then I realized that an attorney is focusing lots of attention on one client, on one particular case. case when you can dedicate 8 hours per day only to one client. But as a lecturer, during the same period of time, I can share my knowledge with 50 students at the same time. And that's why back then I decided that basically I'm being governed by my vocation. My vocation is to be a lawyer. And in Ukraine, we are calling that like vocational activity. I don't know which will be the proper interpretation. That's like a congenial work. But when I felt that I feel too narrow in the role of the attorney, and I liked sharing knowledge with more people, and I liked engaging in information awareness campaign, I became a lecturer. But after 4 years of lecturing, I realized that I like law in dynamics, but teaching activities are more about statics. So, I want more dynamics. And that's why I've realized in the court I can get these dynamics. Moreover, for example, an attorney is looking at some legal problem from one perspective, but I see at myself that I'm looking at the problem not as an attorney, but I'm looking at how this problem will in the future influence the country, the law application. So I understand that that is more like thinking of a judge rather than thinking of an attorney, or that can also be thinking of an academic. But again, in science, I do not feel very comfortable about this statics, that everything is standing on one place. But the court is something that is moving all the time, dynamically. With respect to my capacity to be a judge, I understand that I have a good foundation. That is my knowledge, theoretical knowledge in this particular sphere. And that's also about my practical experience of working in the court as the attorney. But I understand that I've never been a judge, so I will have to apply lots of my efforts, probably more than those colleagues who used to be judges before, in order to master this skill. Quick response, quick decision making. I have these capacities, but here they will be applied in a different role. So I understand that I will have to learn a lot in this sphere, but I'm ready to learn, and I'm ready to invest my time into this training. I understand that I will have limited time for that, but still I'm ready to invest it. And I understand that that's difficult. That's really difficult, but law has always been my vocation, and the lawyer is the profession that is serving. And first of all, it's serving the people. And now, when my country is in the condition of the war, I want to be useful for it, including in the judiciary sphere, and in such an important sphere that is needed for the recovery and development of Ukraine.
One very final question, and as we are getting close on time, I'll ask you to keep your response brief. In your career and in your life, thinking about both your personal and professional life, have you ever had someone attempt to intimidate you or to influence you in a way that made you uncomfortable? And how did you deal with that if it has occurred?
In my professional life, no, I did not have that. But in my personal life, I had it. I provided that explanation in my explanations writing. I don't know whether I should mention details. But if you read the details, I would like not to publicly disclose that. How I addressed that? I went to the State Protection Service, and basically now I do not feel that I have any fear that I have not worked through that I'm afraid to stay on my own. No, I feel comfortable in that regard.
Thank you. And there's no need to share private details. Thank you. That's the conclusion of my questions. Do my colleagues have any additional questions?
Yes, Joe.
Good afternoon, Marta. My name is John O'Sullivan. I just want to follow up on some questions that Jessica asked you about in the beginning about your employment with the gas company in Lviv. You worked there from 2014 to September of 2022. Is that correct?
No, longer than that. So I made a mistake in my questionnaire because I was filling in the application regarding my employment record book. And when I went to work in the university, then my employment record book was in the university. And the last entry was not included into my employment record book. So I just forgot about this last company and I did not include that into my application. But I worked in the oil sector until August of 2023.
Okay. And are you familiar today that this Privat group was involved with that company?
Officially, I do not have this information. I've never seen this information, and officially, I cannot confirm that. But in the news, I read about that, and there were many publications like that in 2025.
And when did you first become aware of that suspected relationship?
Я точно не можу пригадати, тому
I
що
cannot recall for sure because it was some mass media publication, but I cannot even recall which particular and in which year. So it was not official information, but some news publication. But I cannot recall the year when I saw this news.
Was it while you were working for that company or after you left?
ще поки я працювала.
While I was working there.
And why did you leave the company?
Я звільнилася, тому що мені вже
I resigned because I got bored working as a legal counsel. I wanted development. And basically, I was dreaming about teaching throughout my entire life, but I could not teach until I defended my dissertation. But after the defense, I could go and become a lecturer. And I was fine with the university where I was offered a position, and that's why I went there.
When you were employed there and you heard of allegations of illegal activity by the parent company, did you take any action or do anything as a result of learning of that?
По-перше, мені невідомо
First of all, I do not know about this parent company. I have never seen these documents like that, and officially they were not published. Now I do not understand which violation in which sphere. What do you mean? Can you please specify your question?
Let me ask you. You said you had you received knowledge through accounts that you read of the activities of the company. What knowledge did you receive?
Були новини стосовно
There were news about gas stations that they might be related to Privat Group. That was the news publication.
And at that time, what was your knowledge of Privat Group?
Виключно цю інформацію.
Exclusively this information that is available in Wikipedia in the internet.
Well, I mean, were you aware that there were allegations of illegal conduct by that group?
В незаконній поведінці в якій
Illegal conduct in which sphere?
Це було якесь податкове правопорушення.
Was there some tax violation and corruption offense? I just do not understand which particular violation you're talking about.
I don't know what you knew. What I'm asking you is what information you became knowledgeable about while you were still working there.
No, these news that I read in the press were not about some violation or offense. It was the website administered by A95. That's absolutely about all the gas stations in Ukraine. And the gas stations where I worked were related with Privat Group in the media, but it was not about some criminal offense or other offense there.
Okay, thank you.
Yes. I think that we are done. Yes. Thank you, Mr. Chair.
Пане Руслане. Добре.
Okay, Mr. Ruslan. Please. Yes. Thank you, Madam Marta-Mariia, for your answers. For general information, I would like to point out that the HQCJ received information from After-Maidan Civil Society Organization, but those issues that are raised in that appeal were asked by the PCAE, and today they were also voiced during the meeting. So not to repeat myself, I will not come back to them. At the same time, I would like for us now to at least generally discuss some of your professional skills without raising any doubts, of course, about those scores that you got during the qualification exam, but your experience of working course, as you are saying yourself, was mostly related to commercial or administrative law. I would like to emphasize that even those commercial cases that you had quite often were related to local self-governance bodies, that is, public authorities, but still, these were not the cases within the framework of the criminal process. And as you pointed out yourself, the sphere of criminal law and process has been interesting for you since the times of your master's studies. You wrote the academic paper, you provided explanations about those concerns which existed with respect to the possible plagiarisms. No questions about that. My question is the following. Why, in the process of your attorney's activities, we're not even talking about your in-house lawyer because you were doing what you were tasked to do, but why during your professional attorney's activities you didn't engage in criminal cases, in criminal proceedings? And why didn't you combine your theoretical studies with practical activities? Can you please explain that? Thank you for your question. First of all, that is related to the market of legal services in Lviv. It's smaller than in Kiev a bit. So if you specialized only on white-collar crimes in Lviv, especially when you are a young lawyer, you do not have much work. Accordingly, you do not have income. Secondly, I did not attach these proceedings where I was the defense attorney to the application because it's easier now to find a decision in the surname, but you can see that most of my cases were tax-related cases. Wait a second. One. Please continue. So, first of all, the market of legal services in Lviv is not the same as in Kiev. And secondly, I was the defense attorney at the pre-trial investigation stage when there was such an interim measure as criminal case as the temporary access to documents and items. And I was also the defense attorney during interrogations. But I did not provide this information because it's very difficult to find the protocols of these procedural actions. And why? Because when I was the defense attorney under taxation disputes, quite often in parallel there was an ongoing proceeding under Article 212 and under Article 215. But basically in Ukraine we didn't have that many verdicts under this article, so I could not provide verdicts with my surnames. Thank you. Tell me, please. You mentioned that I would like to specify a bit with respect to your work in the university. You mentioned that you developed the course. Can you please tell us in more detail about this particular course that you developed? from the perspective of the position for which you are applying. What can be useful for your work from it? Or maybe it's just like a general course with it has no relation to possible work in the hub. In fact, throughout the period of my work as a lecturer, I've developed several courses about criminal corruption offenses. Of course, my dissertation thesis was the basis for that. So during these courses, I pay attention to Article 364, 364 Prim 1, 365 Prim 2. Also, I've taken into account my practice under Article 212. And when I had a course on economic criminal offenses, there I had many elements about the criminal and taxation offenses. Is the broadcast ongoing? Yes, please continue. Now I have improved this course a bit. And for bachelors, I continue teaching this course from the perspective of substantive law. Mostly it concerns officials and official criminal offenses. But also we are studying some issues of criminology, etc. That's not about practical application, but practically we are focusing on officials, Article 212 and 191. Okay, understood. Thank you. And I have last question to you. We have already partially discussed that, but you are taking part only in one competition for the position of the judge, right? Yes, only in one. Just for general understanding, why were you interested specifically in the competition for the position of the judge of the High Anti-Corruption Court, especially given if you are successfully in this competition, that would imply moving to another city, but you did not apply for any other competitions that are right now ongoing by the HQCJ.
Thank you. That's because for the last 4 years, I have been more dealing with criminal law. The last 4 years, I have almost never dealt with tax law. And speaking about general courts, I don't have such experience regarding any other cases of criminal proceedings apart of internal or service offenses or commercial offenses. That's why for me, the criminal law is known, or for example, I know also the violations or offenses against property or commercial cases I also know. Speaking about HSC jurisdiction and civil confiscation and sanctions topics, I have also worked both with the civil procedural code and with the constitutional law. So these topics are more interesting for me and more relevant for me than, for example, murders or some other cases. Thank you. That's all from my side. Maybe some other commission members have other questions to ask. Thank you. Madam Marta-Mariia, please tell us, can you comment upon or maybe express your opinion? What's the specific, the nuances of lifting criminal responsibility from a person who has carried out corruption-related offense or corruption offense? The nuances here is that it's important to lift criminal responsibility from a person. The only possible way is that's due to expiration of statutory limitations for bringing an accused person to criminal responsibility. Are there any other questions? Please comment upon the following. So you say that the market, so to say, of criminal cases in Lviv is so small in comparison with the same station in Kyiv, for example. But did you try to conclude a free legal aid agreement in order to provide support and services in criminal cases. And there, all attorneys, so they have indeed huge experience in this topic. Yeah, indeed, it's true, but I didn't try it, and because it's impossible to plan your time there. And all the time I was working, for 7 years, I have been working also on my dissertation in parallel with my employment. So I think that in such situation it would be incorrect to take such work, to take such responsibility, because then I would have been forced to not to provide service when all the time when it was needed. And thank you. So it means that, generally speaking, you are interested only in those cases where you feel comfortable. No, not comfortable, but comfortable. I mean that I'm competent, where I'm competent. But you would like to be competent, but you don't want to be competent in wider topics. For now, I can't say that my competence understanding is a narrow one. No, I know how to prioritize, but that fact that I worked and in parallel I also was writing my dissertation, and that's important to take into consideration, and it also shows that I can prioritize and can combine. Thank you. The last question regarding your motivation. You were a legal counsel, and you said that so now you are a lecturer in prestigious higher education facility. Ukrainian Catholic University is quite popular one. At the same time, you say that the law, that the science is static and is not developing. So what about judiciary? Would it not be boring for you? No, I didn't mean it. I meant that as a scholar, you work with a legal problem in static manner, but at a court, you work with this problem in dynamics. So the court is more about dynamics. I didn't mean that the science doesn't develop itself. No, I always was dreaming about to be a lecturer, to teach people. I want to develop myself professionally, but it doesn't mean that if I become a judge, I would stop providing some outreach activities. Thank you. As we have understood that you don't have practice of consideration of criminal cases, but you do it as a scholar, as a lecturer, so you contribute to this area. So have you analyzed doctrine of the HSC? Do you use it in your lectures? What do you can you express any opinion on generalization? And can you express any opinion regarding punishment, for example, or any other questions related to the HCC practice? Thank you. I have been analyzing doctrine of the HCC all the time because I think that it's quite progressive, and very often it provides answers to such questions which have never been thought by different scholars. So at our work, at our lecturing process, we are focused a lot at the HCC doctrine, and also, of course, I use HCC doctrine when I create practical tasks for my students. We discuss them, and I highlight it all the time. But what about some kind of a novelty or a new legal challenge that was considered by the HCC? That you said that HCC showed significant progress. Yeah, the last issue that I paid my attention to, that's cases in absentia, when a suspect or an accused person could join the court hearing remotely when he or she is not present in Ukraine. Yeah, colleagues, I have a few questions now to you. Regarding your motivation, because this topic has already been covered today, but now I'd like to have another perspective on it. So, in your motivation letter, you mentioned it, and now you have also mentioned that you were dreaming about it. As far as I understood, it's important for you specifically to be a lecturer. So to teach people, you started going towards this goal for many years. You started to be a lecturer in a good educational facility. But if you are appointed as a judge at the HSC, given the high workload, you highly likely would not have this opportunity to teach. So it looks like that then you will need to live behind this dream that you have just reached. Thank you for your question. Here, actually, not everyone does like this, but for me, I always compare lawyers' activities with doctors' activities. And for me, it's hard, to trust to a surgeon who will tell how to cut people if he or she has never done it by themselves. So I do want to be a practitioner who is a lecturer also. So I don't forget about my dream, because you can be a judge only till 65 years old. And after 65, it's possible to teach. And yes, I'm aware that within the current station of the judiciary, you will have no time for lecturing and teaching. Thank you. I also looked at your biographical data, and where we have your track record section at the beginning of your track record, where you have changed your employment places so many times. Yeah, maybe it was formal change, informal transfer, but anyway, you worked for different employers for quite short periods of time. Please explain the connection. What's the reason for it? Thank you. It was not my wish to change an employer. No, these were employers who transferred me from one LLC to another LLC. So during such transfers, my employment place was preserved with all the benefits and annual leaves and so on. That was not my wish. That was the first question that we discussed with the PCIe members. Yes, but what were the reasons for such transfers? Regarding reasons, we were all informed on the equal basis that such transfers were done upon agreement between two different employers. We were not informed about any other reasons. But didn't you have any questions like why? Why did it happen? Was it possible for you at least to express your own opinion? My opinion was not asked. I was just informed of the fact. And I had a choice either to have this transfer or to look for another job. The questions that I had were related only to transparency of taxation processes. But as all the enterprises were on the same taxation system, such doubts were not raised because there were no hidden nuances in such transfers. My opinion was not asked, and there was no option for me to influence. And even if I expressed my opinion, it didn't matter at all. I was the legal counsel of the lowest level. Were you angry with such station or frustrated with such station? How did you take it? No, of course I don't like that my working record book, I have such lines. No, I'm not about it. I'm about your relation as a hired employee and with your employer, because it looks like that they treated you like a resource rather than a person, a human being. No, I think that they treat me as a human being, but from the perspective that my official duties were more related to representation in courts rather than to be a legal counsel at certain factory or somewhere else. So major part of my time I spent at courts, and it didn't create any discomfort for me. Okay, thank you. Dear colleagues, any other questions? I have a few short questions to you regarding your capacity to administer justice in the High Anti-Corruption Court. Again, as our rapporteur, Mr. Ruslan, we are not going to doubt your practical task and its evaluation, but I would like to clarify your position regarding certain issues. Why you did such answers specifically? So first thing, you applied punishment in the format of penalty. So you describe the law and how it was applied and so on. All was good. It was, you specifically chose very specific period of time from 4 to 6. So you applied temporary provision of the law, and at the same time you also provided backup version. It's great. But you decided that it shall be 4,000 subsistence minimums. So if we apply a penalty in such an amount, could it be also accompanied with the Article 75 with the probation? So it's corruption criminal case. So that's corruption-related criminal case. And corruption-related criminal cases, Article 75 shall not be applied. The only possible option here, what we have, that's agreement or okay, then your opinion as a professional, as a scholar, what's more important here, or maybe that's equal here, so arrest is not also possible to apply here, am I right? Or not? Why you have opted for penalty, not for arrest? Sorry, because Article 75 clearly defines that I can't apply it, but at the same part, it says that also, sorry, arrest, that's the wrong word. That's Sorry, not arrest. Sorry. Again. So the fine. No. The fine is envisaged in sanctions of that article. So we have applied the fine or the penalty. No. I mean another thing. So you quoted Part 1, Article 75, and you said that it cannot be applied to corruption offenses. But at the same time, at the Part 1, which is quite a huge one, so it says that a part of convictions for corruption offenses, specifically when I'm speaking about correctional works or limitation of liberty and deprivation of liberty for a period of up to 5 years. So it could be there. So it means that fine or penalty is not also listed, is not either listed there. Corruption-related criminal offenses, which are mentioned at the Article 45 of the Criminal Code of Ukraine, shall not be subjected to provisions of Article 75, a part of plea guilty. But what about fines? Regarding fines, yeah, it's possible, but not in relation to corruption cases. But why you think that it's possible to apply fines here? So punishment in the format of the correction works or limited working opportunity and also deprivation of liberty of up to 5 years, taking consideration the gravity of the criminal offense, the court could make a decision to cancel such punishment. Yeah, fine is not applied here, is not allowed here. Yes, that's why I asked you why you based your position not to the measure of punishment, but to the corruption case. Usually they just say fine is not applicable, and that's all. Because to my opinion, here, regarding the fine, it's a general rule which is applied to all criminal offenses, and regarding potential of exemption from regarding corruption offenses, no, it's a specialized provision. Thank you for your reply. And regarding this article envisages not only a possibility to apply a fine, but also deprivation of liberty. Am I right? I think it's like additional punishment. I don't remember all potential sanctions according to this provision. No, I'm not additional. I'm not about additional. I'm about what the prosecutor asked for. Because the prosecutor asked for deprivation of liberty. So here we have two options, deprivation of liberty and a fine. And you described very well positions of the parties, what the prosecutor asked for, what the defense attorney asked for, and the position of the accused person. So they were different. The prosecutor asked for deprivation of liberty for 1 year. And I didn't find justification for you to not to apply it. And Article 374 says very clearly that during a verdict you should justify the option of punishment. So you chose this specific measure of punishment, but you didn't justify it. I don't say that it's right or wrong. It's right or it's normal, but what about justification? Your reason shall be justified. I mean, the court decision shall be justified. You provided the explanation of positions of different parties, but you didn't justify why you opted for one position rather than another. I don't remember. So yeah, the task, that was the task for the first instance. I don't remember the qualification part regarding the punishment and types of sanction, but regarding operational part, I specifically remember that I noted down the reasons, justification, and motives for opting for a specific type of punishment. I indicated there why I didn't opt for deprivation of liberty punishment. I don't see it. Sorry, I don't see it either. I remember that I justified it. Yes, I'm sorry. Did I turn my mic? Or okay, if you don't remember, okay, you don't remember. But yeah, it's clear that justification should be there regarding the choice of punishment. And if you describe different standings of the parties to the process, you need also to justify why you opted for this specific position. Again, I'm reiterating, I don't see the text of my practical task replies, but as far as I remember, I divided my decision into separate sections, and when I opted for specific punishment, I also provided motivation. So you quoted part 3 of Article 68 of the Criminal Code, and you said that the deprivation of liberty is not applied for minors, pregnant women, women with children up to 14 years old, women, people of pension age, and people with the first and second type of disability. So you quoted this provision, but you didn't show the connection of that provision. Maybe it's those materials and the circumstances of the case, there were some facts about the subject of the accused person. No, I mean that unfortunately your decisions were no clear motivation why you actually opted for this punishment. Alexey Emelian, hello. I have a question to you regarding your practical task, specifically as an attorney, as a lawyer in a criminal justice sector. Since 2017, you have been an attorney. And how did you perform these activities as an attorney?
In the form of the law firm. So exclusively, we can talk only about the 2 years of that practical activity. I became an attorney in 2017, and I am still an attorney. And I registered the law. I obtained my attorney's license in the end of 2017. I got the license at the end of the year. Then in 2018, I did not have any clients. And 2019, I registered the bureau. Did you have clients in 2019? Yes. Then my question is, why in the respective field of register of income we have information about bureau's income only starting from 2020? That's not in the register. That's in the analytical note from the NABU, if I remember correctly. And they were providing information about dividends. I paid out dividends to myself only when I had such a profit where I could pay it. If all of my expenses were made on contributions, etc., I did not issue these dividends. As far as I understand, these registers do not reflect payment of the unified tax. I had this question from the PCIe, and I provided all the declarations from 2018 to 2025, where you can see all declared income of the bureau. So in 2019, you also had profit. Yes, so in 2019, I submitted the declaration and I paid the military duty and the unified tax. Okay, thank you. The next question is about vehicles. So we seem to understand the situation with Kia, but I'm interested about the vehicle that you owned before Kia. In particular, 2012,
цього автомобіля відбулося.
Was the year of manufacture of this car. It was sold actually in 3 months after after the purchase of Kia, right? Yes.
Ціна продажу 49 тисяч.
And the price of sale is 49,000, and that was about $2,000 as the amount of sale, correct?
Якщо курс був такий, то так.
If the currency exchange rate was like that, then yes. Okay. Now I'm looking through information from online platforms on the sale of vehicles, and this model also manufactured in 2012. Right now, the sale price after 6 years since then starts from $8,000. Can you explain the price, given that 49,000 is the amount that is 1,000 less than the threshold of financial control? And given that that was your income, so you were supposed to pay taxes from the sale of the vehicle, of course, depending on the sale price. Thank you. First of all, I would like to point out that this car was bought in 2015 using funds of my mother, because back then I hardly on the 1 year of professional experience, I did not have my savings. Then in 2019, when I decided to change the car, I attempted to sell it, and it was put up for sale before I bought the new car. But I could not sell it. I wanted to sell it before buying a new car in order to have more funds. I could not do that. It was on sale for 6 months. Still, no one was buying it from me, and that's why I put it for the sale under power of attorney, and that platform had the power of attorney based on which they sold it. Accordingly, they were responsible for the sale, and I gave it to them in the condition that was not fit for sale. I had some scratches, some things were not operational, and they had to be repaired. That platform accepted the car, prepared it for sale. By the way, in the same register where you're looking for information, you can see that they changed the power of attorney 3 times. So the sale and purchase agreement with the final seller was concluded not by me. I did not have a question about the amount of funds I received, because my mom was buying a car, so my mother took money for its sale. With respect to taxes, that was the first sale of the car for per year that is not taxable. And that's why, in any case, I was not supposed to pay taxes, even though the tax agent was supposed to be that platform responsible for the sale of the car. Okay, thank you. Colleagues, dear members of the PCAE, maybe you have some questions.
Any additional questions, my colleagues? No, I have no additional questions. Thank you.
Добре.
Okay.
Всі питання поставлені.
All the questions have been asked.
Будь ласка, вам надається можливість звернутися
Please, now you have an opportunity to address the Commission, the PCAE members, with concluding remarks. Maybe you would like to provide some additional information, but please be concise. No, I do not have any additional information, but I would like to thank all of you for the time that you are contributing to the development of Ukrainian state and Ukrainian judiciary. Thank you. Thank you for your participation in the interview. Now I'm announcing the interview over. Thank you. Goodbye. All the items of our agenda have been exhausted for today, so I'm announcing the special joint meeting over.